Hello everyone, my name is Louise Atlanting and I've been a water advocate now for about, almost 18 years of my life really. And I'm going to talk to you about pipelines and policies and ways that the public can have a say in regards to these processes that are outside the knowledge that most Canadians actually have on what tools we can use and what mechanisms we can use. And I'm going to talk to you about that. Okay, first off, a little bit of my past here. I've helped stop quarry pits, I've helped stop dumps, I helped stop projects that put water at risk. I also resulted in concessions that added 14 new valves along Enbridge Line 9. So my work is archived at Wilfrid Laurier, and I'm considered a water expert in terms of policy and public participation, mainly because of what I've done. And I actually get results, and I'm going to show you how you can get results as well. Now, when people begin the process of the National Energy Board, they're told that it's accessible to everybody, anyone can participate, anyone can have a say. However, they don't actually tell you how goddamn hard that is to do. It is very difficult. I don't mean to swear, but honestly, it really is. The system isn't designed to have your input. The system is not conducive to true public engagement. It's actually a very top-down approach where they have already decided and you're just brought in around the 11th hour to have your say on the issue. But the National Energy Board is basically funded by the industry. It's influenced by the industry, and if it goes up, it's almost a done deal to begin with at this point in time. We all have reviewed reports by the Trudeau government basically saying that the system is flawed and has to be rebuilt. Okay, with that being said, we know the system is already rigged against us, but there are other mechanisms that can be used outside of the National Energy Board that can be quite effective. Now, going into the National Energy Board process, I heard a lot of people raise issues that were considered outside the scope. Now, what does that mean, outside the scope? That means that in the eyes of the National Energy Board, there's a very limited window on what topics can actually be considered by the board. So say, for example, you go to a National Energy Board hearing and you're concerned about the impacts of tar sands and how that'll be ramped up through the building of a pipe. Well, you cannot raise that issue because according to the National Energy Board, the scope is limited to the physical pipe, not the contents of it. So therefore, impacts upstream or downstream are outside the scope. At least that's how it was for the Enbridge Line 9 and Line 10 hearings. So the weaker points, things that you can actually hammer on in terms of the contents, how to build bulk to your argument in a way that's relevant, focused on the structural integrity of the physical pipe. That means the steel, the welds, where it's placed, and the geology of where the pipe is placed. Now, one of the weakest links I've discovered in regards to my participation in the Line 9 hearings and the Line 10 hearings is that currently there is no regard for baseline geology, none whatsoever. The environmental impact studies were done by folks out in Alberta, and it was done online without any context to the local geology and the local geological risks. Enbridge Line 10, for example, crosses from Nanticoke to Westover. It's located over top the Periscalt Moraine. These are lands that have karst systems, which are underground caves. And if water is introduced in the wrong area, you could see the dissolving of limestone that could result in things like sinkholes or these are how the kettle ponds in the area were formed. Basically, it risks the structural integrity of the pipe. So Enbridge, for example, bypassed a lot of the environmental assessment process by pitching that they could just burrow underneath features like drainage tiles, burrow underneath habitats of endangered species to mitigate risks. And the problem with that concept of burrowing underneath is they don't know what they're burrowing through. It could be archaeological finds because the area is near Six Nations. It could be water tables. It could be all kinds of things under there. Peat. If you ever relocate water from point A to B into a peat area, you would know pretty quick because the peat tends to swell and expand. Or if water goes in, it could contract or expand. It can be quite a mess. So basically, they had no regard for the geology. So geology is a really great weak point to hit. If you want to make a point regarding the risk of a pipeline, they have very little to no regard for endangered species. That's because the National Energy Board is basically exempt from provincial policies regarding the protection of these animals for the most part. They seem to have a carte blanche in Ontario, and that's by design. We need to push for the protection of federal species as a top priority, because the fact of the matter is the animals should be the priority. They're the ones that are endangered, not the pipes, not the oil supplies. It actually is something that we need to work on. But there have been numerous cases where the benefits and the protection of endangered species have effectively rerouted lines or have effectively delayed processes. We have issues of the sage grouse, issues of killer whales, issues regarding caribou. All of those animals' habitats were threatened by pipeline expansions and can be addressed properly, but it usually takes somebody to call the law out on them. So in other words, for the most part, the industry tends to push and violate law until someone actually calls them on it. That's what I've personally found. It's a very, very challenging thing, but that's the culture that we have right now in Canada. They do the same for treaty rights. They do the same for all kinds of different issues. Now, in regards to consultation, it's almost like the National Energy Board as it's functioning right now is a form of SLAP, strategic litigation against public participation, against the First Nations people. What they essentially say to First Nations people is that, you have the right to talk to us, and if you don't speak up at the National Energy Board, well, too bad, so sad, you had your chance. We are acting as the Crown, except the problem is, of course, the National Energy Board has no power for deep duty. So, for example, if they know a pipeline is going to damage a fishery or damage an area, they have no ability to relocate the people or relocate their territorial boundaries to adapt to the pipeline issues. So although the National Energy Board assumes the duty of Crown, they can't perform the same functions, and that's an issue. Also, the National Energy Board has a policy where it states basically that their duty, their burden is to review whether or not the consultations were appropriate. Well, yeah, they're acting as judge and jury in their own process with that. It's reasonably unfair and inequitable. And so what happens is First Nations people have to go to court to contest these issues. The logic was during the Harper era that if a pipeline project is rejected, then First Nations people won't have to contest it. But if a pipeline is approved, they're free to bring it to the courts. The problem is, repeatedly, we're going to the courts over and over and over again for the disregard of our treaty rights and our ability to adapt as First Nations communities. And that ends up creating this strategic litigation against public participation. Because the more fights we fight, the higher the liability is for the community. The higher the costs, the more fiscal duress it creates. And it's a very difficult challenge, and that has to stop. Canada has a charter. Canada has laws that demand reasonable engagement. Prior and informed consent is not something to be taken lightly. Anyhow, beyond the scope of the National Energy Board, even after hearing is issued, and if you disagree with the hearing, there are other mechanisms a person can use to have issues addressed. And one of them, I would say, reasonably, is the Competitions Act. Now, the Competitions Act is it's a concept of protecting the markets from abuse. Okay, so arguments that could reasonably be made under this policy could be things like abuse of dominance. Is Canada reasonably behaving or not? Are they being a fair marketplace where folks can enter and have a say and engage on an equal level? Or are they creating barriers, fiscal barriers against competition? Is Canada doing an abusive process with these National Energy Board hearings, or are they executing it reasonably or fairly? That's up for debate. Are these pipeline companies reasonably communicating with the communities outside the National Energy Board to maintain public safety and to address things like royalty payments and the management of the fiscal components of these projects? Or are they Are they perhaps not handling it as well as it could be handled? So the Competitions Act is free to use. Anyone can file a complaint as long as you have names, addresses, and a situation to describe. Anyone is free to file that and have them review these issues in terms of economic equity, or in terms of the fairness of the marketplace, or in terms of the industry's ability to allow alternative solutions to the same problem. For example, the National Energy Board doesn't have a mandate to review alternative form of energy to resolve the same issues. So where's the dialogue on, okay, you need this amount of energy. Why can't that be used by wind? Why can't that be used by solar? Is it anti-competitive to have a forum that doesn't discuss those? Okay, so we need to go there. We need to start looking at what is the function of the oil, and can it be replaced? And if so, by whom and by what? And why don't we have that dialogue early on? That's all part of it. Okay. Now, after Mr. Harper's Line 9, Line 10 processes were completed, we had this ability to consider climate change impacts through the National Energy Board processes. And at the Line 10 hearing, the way they did that basically was to figure out how much emissions would the trucks have going to and from the work site. That was the limit of the scope. They didn't talk about the tar sands. They didn't talk about upstream or downstream impact. They limited it purely to the function of the construction workers going to and from their pipe. Okay, so that isn't being used as people may think. And that's something for the public to know. Another tool that can be used are complaints through other mechanisms. For example, if a pipe is going underground and it's going to affect a water table, provincial and municipal approvals are needed to do that work. In Ontario, we have a thing called the Environmental Bill of Rights. So when a pipeline is going to be laid or worked on that affects a water table and a water taking permit is required, or disturbance to an endangered species certificate is required, it will be listed on the Environmental Registry of Ontario. And using the Environmental Bill of Rights, people have the legal right to have a say as to whether or not the permit should be issued. That's a great format that people can use to voice their concern about how these projects will have a local impact, on how these projects could put a water table at risk, on how these projects could have adverse impacts to their communities or to the economy, or whatever the frame of your concern. If it's posted on the Environmental Registry of Ontario, you have the right to have a say. And the company, in turn, has the obligation to address your concern. It's not that they can just listen and go away. They have to give a reasonable response. Now, when it comes to endangered species, in Ontario, we have the Endangered Species Act. And what that is when a person applies for a permit to destroy either the animal or the habitat, it could be up several years before a permit is issued. And that's because they have to determine a no net loss to the species and a net benefit to the animal. So say, for example, you know your work is going to kill a couple of these animals. The duty is there to replace them or to expand habitat to allow these animals to thrive. Okay, habitat expansion and the replacement of lost specimens are all part of the big picture. And that kind of thing is a powerful tool. Okay, so people need to be aware of that. Now, a lot of the pipelines during the Harper era were passed using Section 58 of the National Energy Board Act. Now, the reason I'm bringing that up is because those policies, if you read a Section 58 order, they have a deadline marked on it, a deadline as to when that permit expires. And the important thing about that deadline is that you have to stay on top of it, because the industry generally doesn't have an economic motive to really make it public as to when those deadlines are. But anyone who can go to the National Energy Board website, look up the Section 58 order regarding a specific pipe, you could see right on the document, what the deadline is. I know for Enbridge Line 10, the deadline was last month. If there's any work happening on the pipe now, I'd be very curious to know whether or not they have a permit. Okay? So after the pipe has already been approved, there's a lot of ability of the public to have a say in terms of raising concerns, in terms of having an input. Use the Competitions Act, use the Environmental Registry of Ontario, use your local municipality and let them know how you feel about the pipe at all times, because the pipeline company can't dig in your municipality without permission. There has to be a process. Another mechanism that can be used is also the Canada Revenue Agency, if you have concern for things like tax evasion or things that for example, First Nations have treaties, but if there's not proper consultation, is that considered a form of tax evasion? Okay, so we have to start looking at it in terms of what is the effect of their decisions. What are they accomplishing here? Is this a form of tax evasion to not do the job right? Why are they so bad at engineering when it comes to these pipes? Why do they have so little regard for the environment when they do these approvals? Well, a lot of it has to do with how engineers are held accountable or not accountable for their work. When a project has an engineering firm reviewing it, it's usually a third-party engineering firm. They sign off on their work, and then Enbridge or TransCanada or whatever other pipeline assumes the risk of that work after the fact. So what we need desperately in Canada is a mechanism to hold the engineering firms accountable for their work or lack thereof in regards to these projects. So say, for example, if a pipe ruptures because they didn't bother to look at the sediment composition under the pipe, they built it over a peat bog or they built it over top an area that sank, they should have some kind of mechanism to hold them accountable. So what I would like taxpayers to do is to contact their local MP and hold the accounting firms accountable by encouraging that when a pipeline is approved, the government gets to hold a value of the check for the engineering firm that did the work. And if the pipe breaks because the engineering was poor, cash it. We have to start holding the base engineers accountable. Otherwise, the work that they do will be complete crap. If there's no measure of fiscal accountability, we will not see the quality of work that we need to see in order to protect our economy and our communities for the long term. Okay? Write your MP. Say whenever there's a pipeline built, please hold a check with the value of the engineering service that allowed for this pipe to be approved. And if it should break because of their lack of regard for the risks, cash it. Okay? I think that's one of the strongest things we can do to help assure better quality of work, and it shouldn't be limited to pipelines. This should apply to all major projects, whether it be a dam, whether it be a power grid, whether it be whatever. We have to protect ourselves. As taxpayers, we need to protect ourselves. And the truth is that right now, with the oil sector as it is, the true value of the remediation associated with spills and the remediation associated with the cleanup in Alberta has to be assessed. Otherwise, it's going to just be downloaded onto the taxpayer. Don't let these people declare bankruptcy and get away with it. Okay, we need reasonable accountability. So hold the engineers accountable today and then let them see whether or not they want to go through with this. That's about it. So I'm giving you my 2 cents worth, and I hope it helps to shake the tree a bit, that we get some good fruits falling from it. Thank you very much. Bye-bye.